For the Government Accountability Series has been advertised that the Attorney General and Minister for Justice, Dr. Dominic Ayeni, is expected to take his turn today. Let's take you there right now, where the Minister for Government Communications is introducing him. Then we're listening to the update he has for us.
I would invite the Honorable Dominic Ayeni, Minister for Justice and Attorney General, to take the microphone. Thank you very much. Honorable Minister, the microphone is yours.
Thank you. Good morning, ladies and gentlemen of the media. As the Honorable Minister for Government Communication has indicated, I am here to give you an update on the developments that occurred last week with respect to the nolle prosequi filed in the Dufour case, in the Republic versus Governor Dufour and 7 others, and then also to update you on the ongoing investigations and prosecutions that I have initiated. But before I go into the details, I would want to first of all apologize for the fact that we had advertised that I was going to update you on a major investigation that has taken place that adopted the rumble in the jungle. You will recall that when I announced the investigation of the Kobina Eduboahin case, I ended up by saying that if you thought that case was a thriller in Manila, then wait for the rumble in the jungle. And so the rumble in the jungle was supposed to be today, but unfortunately, after the press release from my office in the Dufour case, significant public commentary, some of it adverse, others very positive, came into play. And I decided that it is, as part of the accountability and transparency series, it is important for me to provide details, because certain misimpressions were created which are not accurate when it comes to the decision that I have taken. So I want to provide details on that. And then I'll update you on what we are doing, myself, my deputy, and the team at the AG's department with respect to the prosecutions. So, ladies and gentlemen of the media, my fellow countrymen and women, I am here this morning to account to the sovereign people of Ghana, as has been my practice since assuming office as Attorney General. Today, I will do two things. Firstly, I will provide further details on my decision to enter a nolle prosequi in the case of the Republic versus Governor Dufour and 7 others. And secondly, give an update on the ongoing investigations and prosecutions that I have initiated upon assuming office as Attorney General. On Tuesday, 22nd July 2025, I took the decision to enter a nolle prosequi in the case of the Republic versus Kobina Dufour and 7 others. This decision effectively brought to an end the criminal trial of Dr. Kobina Dufour, a former governor of the Bank of Ghana and former Minister for Finance. I took that decision after a prolonged period of negotiations with my team of state attorneys, including the Director of Public Prosecutions and the receiver of UniBank on the one side. The team on the other side was made up of Dr. Dufour, the shareholders, directors and managers of UniBank, and the receiver. As part of my constitutional duty to account to you, my fellow countrymen, I wish to provide further details on my decision for two reasons. First, I have always maintained that as your Attorney General, I owe you a duty to act transparently. Second, I think it is important to dispel certain misimpressions that arose as a result of the rather terse press release that I issued following the filing of the nolle prosequi. My fellow countrymen and women, in March this year, the lawyers for the UniBank directors and shareholders approached me with a proposal of their clients' intention to settle their indebtedness to UniBank. In response, I convened a meeting on the 25th of March with them, representatives, and the receiver of UniBank Mr. Ni Amano Dodu. At the meeting, it became obvious to both parties that a reconciliation of UniBank's account with the Bank of Ghana should be conducted. Therefore, I authorized the receiver to engage in the reconciliation exercise with them to determine the full scope of UniBank's exposure. I directed that the parties adopt a holistic approach that combined liabilities under both the criminal proceedings and the ongoing civil proceedings, because they were obviously interrelated, in order to reach a unified resolution that will bring closure to all related matters. The objective was to assess the feasibility of a comprehensive settlement. The charges in the criminal case against the accused persons involved a total amount, and this is very important, a total amount of 1.2 billion Ghana cedis, not 5.7, as is being bandied about from certain quarters whose names I would not want to mention. While the civil case involved a total exposure of 5.7 billion Ghana cedis. Now, ladies and gentlemen of the media, if you conduct your research in the High Court, you realize that the receiver subsequently amended the writ of summons and the statement of claim and revised the civil liability down to 2.8 billion Ghana cedis. Okay, so that is on record. That's a public record, and whoever wants to contest this is at liberty to go to the High Court and then, do so. It is important to state for the avoidance of doubt that the total exposure in the criminal case is part of the total civil case exposure. In other words, the 1.2 billion is not in addition to or on top of the 5.7 billion, which was revised down to 2.8 billion. The charges in the criminal case against the accused persons involve a total liability. No, sorry, I think I'm repeating myself. Now, the 5.7 billion was made up of the following. That is from the initial, stage of the case. 2 billion being loans and advances which UniBank made to related and connected parties. 3.7 billion being payments made on behalf of or on the instructions of the accused persons. Included in A and B above, however, was an amount of 2.1 billion which was alleged to be fictitious loans, to have comprised fictitious loans and fictitious transactions booked by UniBank prior to replacement in official administration. During the reconciliation exercise, the accused persons objected to the inclusion of the 2.1 billion on the grounds that the amount did not involve any direct cash outflows which could be recovered. The accused persons also objected to the inclusion of placements of 0.3 billion, that is 300 million, made to Unisecurities. Now, Unisecurities is a Securities and Exchange Commission regulated, not a Bank of Ghana related company that had been placed in liquidation and for which a claim had been filed with the official liquidator. In other words, the money was to be recovered. The recovery of this amount is being pursued independently through insolvency proceedings with the official liquidator of that entity. In summary, the above matters led to the revision of the previously reported exposure of 5.7 billion down to 3.3 billion, which comprised the following: the exclusion of 2.1 billion in the alleged fictitious amounts booked to the account of the shareholder who did not involve cash outflows. In other words, monies didn't go out to anybody. These were just book entries that were designed to make the books of UniBank look good. That is how come that in the criminal case, the charge of falsification of accounts was brought against them. So they did not loot the money. They did not give the money to anybody. They just made entries that were meant to give Bank of Ghana, the central bank, the impression that the bank was doing well. Okay. Then the exclusion of 0.3 billion relating to UniBank's placement with a SEC-regulated, SEC-regulated related company currently in receivership, which is being pursued separately through the insolvency proceedings. After prolonged negotiations, the accused persons, by a letter dated 7th May 2025, made a proposal to settle the revised outstanding obligation of 3.3 billion Ghana cedis through a structured approach. The accused persons offered to pay 2 billion Ghana cedis in full and final settlement of the outstanding obligations through the following arrangements: 800 million worth of assets to be transferred directly to UniBank, which is in receivership, which will now make that available to the Bank of Ghana. And then their active cooperation and participation to assist the receiver to recover an additional 1.2 billion from the direct beneficiaries paid out on their instructions. Out of the above arrangements, the accused persons have provided landed properties valued at 824 million Ghana cedis to UniBank, that is, in receivership. Further, in other words, indirectly to the Bank of Ghana or the Republic of Ghana. Further, the accused persons will be responsible for any shortfall in the proceeds realized from the sale of the landed properties. A total of 0.5 billion has to date been recovered out of the 1.2 billion being pursued from the direct beneficiaries. Recovery of the remaining balance of 0.7 billion out of the 1.2 billion Ghana cedis and the realization of the landed properties provided are expected to be completed over a timeline of 18 months. Although the preference would have been for me and my team for the accused person to settle the proposed amount in cash, immediate settlement in cash was not, from my sense of what transpired at the negotiations, a realistic possibility or a realistic option. In assessing the proposal submitted by the lawyers for the accused persons, I took into account the following factors. The receiver of UniBank acknowledged that the fictitious amounts totaling 2.1 billion did not result from cash outflows, but related to accounting entries that overstated the asset base of the bank, which predated UniBank's placement in official administration. B, a claim for the placement of 0.3 billion with the SEC-regulated entity was filed by the receiver with the official liquidator in 2019, and its recovery is being pursued separately through the insolvency process. 3, both the criminal and civil cases have persisted over 6 years with no immediate resolution in sight. The complex nature of the legal proceedings has significantly delayed any meaningful recovery. Now, come to think of it, those who instituted the criminal proceedings did not foresee the possibility down the line of recovering assets and never engage in any asset recovery process. They did not trace, to find out what assets were in the hands of third parties, including those who were in court. So while the criminal prosecution was intended to serve as a punitive and deterrent measure, it is through the civil process that actual recovery of funds is effectively pursued. The accused person's proposal fell within the receiver's mandate to maximize recoveries for UniBank in order to settle the bank's creditors, mainly Government of Ghana and some institutions. There is also a genuine risk that prolonged litigation could ultimately lead to lower net recovery, especially when accounting for legal costs, procedural delays, the time value of money, and the potential dissipation or concealment of assets. By contrast, the current arrangement secures the timely resolution or recovery of over 800 million Ghana cedis in assets and establishes a structured pathway for recovering an additional 1.2 billion Ghana cedis with the active cooperation of the accused persons. On the other hand, should the matter have continued in court, it would likely have faced prolonged delays, including multiple procedural applications, adjournments, and appeals. Even if judgment were eventually obtained in either the civil or criminal proceedings, enforcement and execution could take years, further deferring any meaningful recovery. It is clear from the foregoing that I took a pragmatic, holistic approach by engaging the receiver and the accused persons to broker a resolution that settles both the criminal and civil dimensions of the case. This strategy recognizes that while criminal proceedings are punitive, the real economic value to the state lies in a non-conviction-based asset recovery approach. The terms of the settlement are structured to ensure that the Attorney General, the Bank of Ghana, the Minister of Finance exercise oversight over the recovery of the negotiated amounts. Progress under the agreement will be subject to quarterly reviews to ensure that the accused persons fulfill their obligations as agreed. Ladies and gentlemen of the media and my fellow countrymen and women, it is important to correct certain misunderstandings or distortions, deliberate in some cases, that our team picked from the media space regarding this matter. Since my press release, it has been said that by setting a minimum threshold of 60% for the recovery of assets as a condition for filing a nolle prosequi or terminating the banking sector cases, I have cut a deal which permits persons who have stolen or looted public funds to walk away with 40% of the loot. At least that is the narrative, by some sections of, the Ghanaian populace, particularly from our opponents in the MPP who were responsible for all this mess. Indeed, one writer on Facebook compared my decision to the situation where someone has stolen 6 goods and is being told by the prosecutor to return 4 goods and keep the 2. But my fellow countrymen and women, now this may seem like a joke, but it's a very serious expression of the sense of justice of our community. And it is something that I have used, to, get people who have come to me for plea deals to check them to think about the community's sense of justice. So, it is not lost on me, and I wasn't surprised when I read this on Facebook. But the goat thief analogy, intriguing though it may be, is an oversimplification of the matter. This is why. First, Dr. Kobina Dufour and the other persons standing trial were not charged with stealing or looting of public funds. They were charged with causing financial loss to the state, fraudulent breach of trust, falsification of accounts, as I've pointed out earlier, dishonestly receiving, and money laundering. But the facts and the evidence supporting these charges never allege that those standing trial personally benefited from the banking transactions that gave rise to these charges. Now, it's important to make clear that when someone is charged with, for instance, causing financial loss to the state, all right, it does not imply from a criminal liability point of view that they took the resources that have been lost. In other words, what we seek to do when we charge someone with causing financial loss to the state is to prove that they either intentionally or recklessly or negligently caused the state to lose resources or to lose funds. All right. Now, those of you who are old enough to remember the Quality Grain case, which came, and went all the way to the Supreme Court, involving the former Deputy Minister of Finance, Victor Salome, and a number of NDC officials in the Rawlings regime. You'll remember that in that case, Justice Afre was at pains to point out that though the accused persons had been convicted of the offense of causing financial loss to the state, they had not been convicted of stealing. They had not been convicted of personally benefiting from, the actions that were the subject matter of the criminal charges. All right. We must also understand that though the charge of fraudulent breach of trust is closely related to the charge of stealing, the facts and the evidence didn't show, okay, that in this particular case, they fraudulently breached their trust because they stood to benefit. Okay, they entered into transactions with third parties, okay, which pointed to the fact that according to the case that was filed, they were trustees of depositors' funds. Now, which in itself is legally contestable, right? Because the banker-customer relationship is not one of trusteeship. It is one of contract. Now, that is legally, established in case law. There are case law precedents to the effect that that relationship is not one of trusteeship. So when someone deposits their money in a bank, all right, they are not keeping the money, they are not giving the money to the bank to be held in trust. Okay? So that if that were the case, then the beneficiary would be the one dictating how the monies, should be used. But banks are at liberty, because it's a contractual relation, a commercial relationship, at liberty to lend the monies, do, banking transactions with those funds in the way that they see fit, but in a prudential manner. Okay? So the basic point I'm trying to make is that these charges were themselves legally contestable. All right? Second, the analogy assumes that these charges, that is the goat thief analogy, assumes that these charges could be proven beyond reasonable doubt. On the contrary, the record shows that the charges were contestable, and there was a high likelihood that the defense could have raised sufficient doubt to procure an acquittal. And if that happened, as seen from the Beige Capital case, I would not have been able to recover even 1 cedi. Now, ladies and gentlemen of the media and my fellow countrymen and women, when I did the press release, I did not mention Beige Capital because at that point in time, I did not know that the decision was coming down. Now, as Providence would have it, the decision came a day after, right? I can now disclose that Beige Capital offered me or my office 10 million Ghana cedis. You can ask the lawyers for Beige Capital. Ask lawyer, Tadio Sori. They offered 10 million Ghana cedis in settlement, and I refused. Today, I can't get 50 pesos from Beige Capital. So the dynamics are complex. Those who are oversimplifying it and saying this is the good, thief scenario, must understand that, it is more complex than just saying that the Attorney General says bring 4 goats and then keep 2. Third, by the time I assumed office and was approached by the lawyers for the accused persons, no asset tracing had been undertaken and no freezing orders had been obtained by my predecessors who filed the criminal charges. I could have been faced with a situation where the thief would have eaten 4 of the goats, thus leaving me with only one possibility, to recover only 2 goats. All right? In other words, assets depreciate and may even disappear before a diligent prosecutor can lay hands on them. Now, those of you who have followed developments in the, the tracing and recovery of the assets of General Sani Abacha, you remember him, the Nigerian military leader who died, I think, in 1998. Okay? You will realize that, he shipped a lot of the assets overseas, mostly to Switzerland and other parts of Europe and the United States. As we speak, okay, from 1998 till now, the recovery process is still ongoing. And even with the sophistication of the Swiss authorities and the US authorities in collaboration with, Nigerian authorities, recovery is still ongoing. So it is more complicated, than that. For people to think that it is just a question of the goats sitting there and for the Attorney General to say, bring all 6 goats back. But as I have crudely put it, if 4 of the goats have been used for light soup, how do you expect me, to retrieve the goats? Of course, jailing the person is also part of the process of accountability. And I do understand when Ghanaians say we should, jail them. But if we focus on the recovery, it will be very illusionary for anyone to think that the Attorney General or the Republic can recover 100% in every case. In some cases, I may be lucky, or let me say the state will be lucky if the assets are still there, they've not depreciated, they are there in full, and I can lay hands on them. That is how come that, if you have noticed since I came into office, we have always investigated the criminal conduct together with tracing the proceeds of crime. There has been no except in the National Service case, there has been no a major announcement of investigation that has not included the assets of the criminal enterprise. And in the National Service case, I want to let you understand that. You remember that the Fourth Estate broke the story. Okay? The Fourth Estate broke the story in October. The people who were involved knew that ultimate accountability will be exacted. So they would have, as rational actors, do you expect that the luxury cars they bought, the houses they acquired, all the assets, the bank accounts would still be staying intact, waiting for the prosecutor to come and then lay hands on them? No. So we are doing asset tracing in that case. But it has been very difficult because they started the process of hiding their assets way back in October 2024. But yet, we are coming upon a number of them, and I will make those available at the right time. Lastly, in respect of the case at hand, 100% recovery was not possible, and a conviction was not guaranteed. In the circumstances, my team and I agreed to set a realistic threshold of 60% recovery. Sorry. We recovered 824 million worth of assets, which will be handed over to the state, and established a structured pathway for recovering the additional 1.2 billion Ghana cedis through the civil, process. And these are monies that are being held by third parties that owed UniBank, including, for instance, and I think that this is very important, contractors owed UniBank at the time that it was placed in administration 2.9 billion Ghana cedis. UniBank made overtures to the state to say, look, the Minister of Finance, pay the contractors and let the contractors, because they will be paid through our bank, we can take the 2.9 billion and we can satisfy, our books will, improve, and we can stay afloat as a bank. The then Minister of Finance flatly rejected that and put and with the help of the Bank of Ghana, put UniBank into the situation in which we find ourselves. All right? Our current finance minister could have put NIB through the same process, right? But instead of using money to collapse a bank, the Honorable Atuforsen has used the money to revive it, for it to keep jobs and then continue to operate in the in the banking sector. That is what is called wisdom in governance. Having explained my decision to enter a nolle prosequi in the case of the Republic versus Kwabena Dufour and others, I wish to provide a brief update on the investigations and prosecutions that are currently underway. Trials have commenced in the case of the Republic versus Kwabena Dufour and 3 others, and that of the Republic versus Solomon Asamoah and another. That is the SkyTrain case. In the Kwabena Dufour case, we are calling only 3 prosecution witnesses. Our first witness has concluded his testimony, but for the third accused person sudden withdrawal in open court of a lawyer's service, our first witness would have been discharged to give way to the second prosecution witness to start testifying. We expect our second witness to start testifying before the beginning of the legal vacation on July 31st, 2025. In the SkyTrain trial, we have concluded the case management conference. It is important to add that, but for the change of solicitors and the multiple medical excuses of the second accused person, that is Prof. Ameyaw Ekumfi, and recently of the lawyer for the first accused person, we would have called 2 of the 6 witnesses by now. That notwithstanding, the trial in the SkyTrain case is expected to start before the beginning of the legal vacation. The National Service Authority scandal case was due to be filed last week, as promised, when we stumbled upon evidence of malfeasance involving an account at the Bank of Ghana to which had been transferred an amount of 189 million Ghana cedis. Out of this amount, 80 million Ghana cedis cannot be traced. But we found 2 checks bearing the name and account details of the former Director General, Mr. Ose Asibe, which had been used to withdraw funds totaling a little under 2 million Ghana cedis from the said account. We have therefore halted the filing of charges so as to await the receipt of the evidence from the relevant state agencies, including the Bank of Ghana, Ministry of Finance, and the Controller and Accountant General's Department. In fact, as I speak, the Bank of Ghana signaled to me that this morning they are going to deliver the entire, bank statement, for my attention. I am, however, thank you. Sorry. I am, however, happy to announce that at least 8 suspects in this investigation have approached my office for plea negotiations, including 3 former officers of the National Service Authority. Some officials have offered to testify against their colleagues, and some vendors and service providers are willing to come clean and testify as prosecution witnesses. When you build your docket well, this is the result that you get. 8, people are willing to testify. Persons, they are not coming to say hearsay. They are not coming to give hearsay evidence. People who were involved, okay? And we are, in negotiations with them and their lawyers. As a precondition, I tell them, you bring back the money that we have calculated that you took, you serve as a prosecution witness. That is the approach that we are using. Now, I'm sure the MPP will be very happy for me to insist that 100% be returned to the Attorney General before any deal can be, cut. Now, a report on the docket for the oral cases, including the mathematical sets, the All Africa Games, and the drip scandals are being prepared by the National Investigation Bureau for my attention. I expect to receive that investigative report in a few weeks for work to begin on filing charges in court. The Economic and Organized Crime Office has completed investigations in respect of Wontumi, Chairman Wontumi, and the former National Buffer Stock Company CEO, Mr. Abdul Wahab Hanan, and their accomplices. The results of both investigations will be announced very soon. The police CID have also completed a docket on the Akonta mining case and submitted same to my office. We have prepared charges and sent them back to the police CID for the suspects to be formally charged before their arraignment in court in the coming days. Ladies and gentlemen of the media, my fellow countrymen and women, in conclusion, I wish to remind you of the fact that when I announced the Kobina Idubohin investigation, I was blunt in stating the fact that I am open to engaging in plea bargaining with those who have been investigated and found to have looted or stolen state resources. I minced no words about my intentions and will therefore not shut the door to any accused person willing to enter into negotiations with my office for purposes of reaching a plea agreement. My approach is in consonance with the central plank of the oral, which is to recover the loot, which is to recover all the loot. But of course, you use oral, all advisedly, because as I have pointed out clearly, it is not in all cases that it is possible to recover all the loot. So you recover some, realistically possible. Of course, recovering the loot and jailing looters are not mutually exclusive. And I believe that that is what citizens are pushing for. In other words, both can take place, and that will be full-fledged accountability. But anyone familiar with the plea negotiations would agree that it is rare to go into the negotiation room and come out without giving up something in order to clinch a deal. Our plea bargain statute captures that succinctly, as it contemplates that the Attorney General may even go to the extent of dropping charges in exchange for restitution. Also, under the Costs Act 1993, Act 459, an accused may plead guilty to a charge or charges and pay restitution where the offense involves harm to the property of the Republic, including financial resources. In that case, the accused is to be handed a non-custodial sentence. As the Attorney General, I will not oppose the use of Section 35 of the Costs Act to achieve the purposes of oral. Now, Section 35 is mandatory. Once the accused approaches the judge, okay, and pleads guilty to the charge, the judge is mandated the judge could reject the restitution or reject the offer of the accused person. But once the judge accepts the offer of the accused person, I have no role in it. All right? Then the accused person must be given a non-custodial sentence. In other words, the accused person will walk home. So those who are saying that you are cutting a deal and letting criminals walk must understand that, okay, even the legislative framework existing at the time that I was in law school, I was in final year in Legon when this act was enacted, okay, contemplates that in some cases, the accused can pay restitution and get a non-custodial sentence. So if any accused person offers to come under Section 35, please, ladies and gentlemen, that is what Parliament has enacted. The Parliament of the first Parliament of the Fourth Republic do not expect that I will be able to say, do not impose. If once the judge accepts it, okay, I can make my representation to the judge as to why this is not a fit and proper case for restitution and a non-custodial sentence. Okay, but that can be rejected because the statute imposes, right, the power and authority to determine the circumstances under which that will happen in the judge, not in the Attorney General. The Plea Bargain Act, on the other hand, okay, imposes the power and authority to, negotiate the deal in the Attorney General. However, the judge has a role to play. The plea agreement must be endorsed by the judge before, it is accepted. Finally, make no mistake, ladies and gentlemen, about my intentions. I want to jail persons who have looted state resources, but at the same time, I am pragmatic enough to know that it is not in every instance that that is possible. In those circumstances, I will opt for non-conviction-based asset recovery. I thank you very much. Thank you.
Yeah, thank you very much, Honorable Attorney General, for that comprehensive briefing. As he indicated at the beginning of his remarks, the session on Ramble in the Jungle will take place sometime next week. He did not want the magnitude of that case to compete with the need for accountability in the decision that he took in the UniBank case. So we decided that he speaks to this matter today. And then on another opportune occasion, he delves deeper into the Ramble in the Jungle. At this juncture, we will take questions from members of the media present.
Right. So, good morning. My name is Shadrach Odamejare, Metro TV. My question has to do, or is around the bank, the cleanup. The president during the campaign promised that banks that were merged will go back to their former state. What happens to the likes of the consolidated bank? And then also on the Ablikuma North rerun.
That is not a matter that the Attorney General will speak to. It is a policy decision that will emanate from the finance ministry. Yes.
On the Ablikuma North rerun, we heard some people have been arrested. What is the newest on that? And then with persons engaged in Galamsey, arrests made, and then so far, what's happening? Thank you.
Okay, all right, thank you.
Yeah, my name is Maxwell. I work with Joy FM and then Joy News. So filing a nolle prosequi is not an acquittal in itself. I want to find out from the AG that in the face of emerging evidence, in the case where we have emerging evidence, compelling evidence, is he willing to reopen the UniBank case? And then the second question would also be about the deportation of some illegal miners. Some weeks ago, the Interior Minister announced a major policy shift. He said, we're not interested in prosecuting foreigners engaged in illegal mining. I want to find out how many of them have been deported, so far.
But again, I have constantly insisted on the need to keep questions relevant to the sector. The Interior Minister was here. He made a pronouncement. He was here. You asked him, he answered. So
And
why would you then bring?
No,
it to
you
Attorney
promised that the AG would answer that question. In fact,
No.
two ministers
You said-
came earlier,
you said-
and you promised that
No,
the
but you
AG would
mentioned- you
answer that
mentioned
question.
You mentioned the
My
interior
colleagues
minister.
will attest to that.
Relevance.
My colleagues will attest to that. You said the AG. Anyway, thank you.
The interior minister is the one who does deportation, not the AG. So you can't ask him about deportation.
I
You can
asked
ask him
the
about
interior
prosecution.
I asked the
That's
interior
why
minister.
that your colleague asked about prosecution, and it was allowed because it was relevant to the AG's work. Deportation is a remit of the interior minister.
Yeah, but I asked him, and you said the AG
No,
would
I didn't
answer.
say so.
But it's fine. It's okay.
You asked about the airline, and I said that would be handled by the environment minister. Yeah, exactly.
Good morning. My question is in relation with the legal education in Ghana, if I'm allowed.
Sure.
Okay, thank you. So currently there are few law faculties. So currently there are few law faculties in Ghana. That includes both public and private universities. So the public universities have more support from government, whilst the private universities do not have. And unfortunately, not everyone will be able to attend the public universities. So I want to ask that what measures are in place to bridge the gap between the public and then the private universities that are running the LLB programs. And then the second question has to do with the President, His Excellency John Dramani Mahama, as part of his manifesto promise, stated vehemently that there is the need to reset legal education. And reset here means that he expanding legal education, where law faculties will be made to train their own lawyers who will take a general legal education at the end of the studies. And quite recently, Honorable
Your question is
Roxanne
becoming rather
Nelson
lengthy. Yes, if you wrap
reiterated
up,
government's position. So I want to know when the bill will be laid in Parliament.
Okay.
Thank you.
All right, thank you.
It's okay. Thank you. Minister Abdulhanan Adam, EIB Network. Minister, my first question has to do with the UniBank issue. It will be recalled that the shareholders argued themselves and through their lawyers in court that the amount they were being accused of stealing to buy properties, allegedly.
No such charge.
Okay,
available against
so
them.
the properties they were said to have bought were indeed in the books of the bank. However, all that needed to have been done was to reassign. Okay, all that needed to have been done was to reassign the properties from holder in whose name they had been registered to the bank. Could you kindly explain if this has been done and how it works? Secondly, I want to find out from you the issue of prosecuting persons involved in the ECG issue. Have you started that, and when should we expect that to happen in court? Thank you.
Okay, so let the Attorney General answer this set, and then we'll come back and take more questions, given the length and number of the questions asked so far.
Thank you very much for the questions. I think some of them, as the Honorable Minister for Government Communications pointed out, are better directed, to some of my colleagues in some of the sectors. For instance, if you ask what will happen to CBG, that is better answered by the Minister of Finance and the Governor of the Bank of Ghana. Now, with respect to Abdul Kumanov, the arrests have been effected, and you know that when arrests have been effected, you don't go straight, to court. You need to conduct an investigation, prepare a docket, and then you proceed to charge. So that is taking place, and we are taking a very serious view of all electoral, violence. Okay, violence arising out of or in connection with all elections in this country. So for us, it's very comprehensive, and the president has, made it very, very clear that it doesn't matter which side of the political divide you belong to. We will investigate and prosecute, all of them. Now, when it comes to the illegal mining, prosecutions are taking place. Okay, we are prosecuting. In fact, we have decided that we are setting up more special courts. Okay, under the New Patriotic Party government, the former Chief Justice Eni Yeboah, designated certain courts as special courts for illegal mining prosecutions. Okay, so we are going to expand those ones, and then also when the tribunals bill, the public tribunals bill, is ready, I have submitted it to Parliament. We'll be sending a lot of them to the public tribunals at the district level for prosecution all over the country. In respect of deported Chinese, as the Honorable Minister has pointed out, I don't have the statistics. Okay, these are better gotten from the Minister of Interior. Now, on legal education, the question was a bit lengthy, but what I picked up are two things. Bridging the gap between the private law schools and the public law schools. Now, I don't know what you meant by bridging the gap. If you are talking about government support, someone who establishes their private, a university, has the obligation to find resources for that university to, operate, in terms of, being able to run all its programs and so on. So it is not a duty. If government wants to subsidize them, that is a different matter. That's a privilege, not a right. So I don't think that government will be pouring. In fact, we are having difficulties funding all the existing public universities. And to add the private universities to our load is not, I think, a very prudent thing to do. The second thing that I picked up was with respect to the promise to reset legal education. And that is very, very important. And that promise is that we are going to reform legal education in such a way that access will be expanded. Okay, so that currently we have thousands of LLB holders who cannot get to become lawyers because they cannot enter the Ghana School of Law. All right. We want the bill that I have drafted and which is will be submitted to cabinet next month. Is to the effect that we are going to literally abolish the Ghana School of Law system. All right. Basically, what we are going to do is that you will have 3 years of legal education to obtain your degree. That is the LLB. After obtaining the degree, the LLB degree, you now do what we call either the clinical legal program or the bar practice course in the university where you got your LLB for another academic year. And then you write what we term the National Bar Exam. Okay, so everybody who has the LLB and who has taken the bar practice course in their school, in their university, all right, will be entitled to write the National Bar Exam. So it will be like what the accountants do, all right. Once you qualify to write the examination, the Chartered Institute of Accountants will administer the exam, and everybody can write. And if you pass, you become a chartered accountant. That is what is going to happen in order to expand legal education in the country. So the bill, as I speak, in fact, is interesting that you asked, because I forwarded the final draft to my able deputy, an academic, Justice Remsai, to review and then give me his input before we submit it to cabinet. That was just only yesterday that I sent it to him. Then there is a question of the assigning of the properties. Okay, that was something that the shareholders, kept saying. You see, the whole case centered around these related parties, activities, okay, transactions, okay, where Holder Holdings, Uni Securities, of course, in the press release, you remember the 0.3, billion, which was given to, which was given to Uni Securities, which is a SEC regulated entity, which is being pursued. Okay, so the whole idea, that is why the misconception being spread by certain elements, certain citizens, to the effect that Dufour and his family were basically looting, resources from the bank, is misplaced. Okay, these were all related entity transactions. Okay, and I will encourage all of you. You should probably read the Beige Capital Court of Appeal decision, because the scenarios are the same. All right. So they were insisting that, look, if these are properties held by related parties, simply just transfer them to UniBank, and then you will have you have recovered enough to be able to satisfy the liability. But that was something that was in dispute in the case. Okay. Now with this settlement, it brings all those matters to rest. Secondly, you asked about the ECG. Prosecute. Yes, but that's what I'm coming to. Yes. So the missing containers investigation, I was given a preliminary report on it. Okay, I reviewed the report and I sent it back to the Director General CID to do further investigations. I directed them, and that is what we do in the office. When we read an investigative report and we see gaps, because all that a defense lawyer needs to do is to raise reasonable doubt, okay, and then the case will be thrown out. In order that we prevent a situation where reasonable doubt is being raised, we seal the gaps before we charge the people, and we have sent it back for them to be to do further investigations. Thank you.
All right, thank you very much. So we'll take another round of questions. As I've indicated, the question must be relevant to the briefing or the remit of the Attorney General. No extraneous matters can be brought in.
My name is Wisdom Hedejime. I work with the XYZ Broadcasting. Minister, regarding Section 35 of the Courts Act and the plea bargain, how do we marry the two? And would you recommend that the Constitutional Review Committee relook at that provisions? And then number two, you said you want to prosecute people, and it's something you want to do. Which key issues are the cases that you want to stamp your authority, regardless, to see people in Sawong?
Kamala Kluche, I work at TV3. Now, still on the UniBank case, was the agreement made with the accused reached under the Plea Bargaining Act? If yes, are you willing to make public this agreement? And if no, why was agreement not made under the Act? And also, will your office consider the possibility of requesting for vacation courts to continue with the cases of oral, looking at the magnitude of the cases and also the time frame in terms of how constrained you may be looking at the number of years you have?
Thank you very much.
Thank you very much, AG. My name is Patrick Asot-Boedu with Radio Gold. Unfortunately, through your presentation, I didn't hear cases like the PDS scandal. I didn't hear of the National Cathedral project scandal. I didn't also hear of the, I did not also hear of the Dr. Hamid Mustafa, the former Chief Executive Officer.
But Patrick, that is a matter being handled by the Office of the Special Prosecutor. So how does the Attorney General come to speak about a matter that is being handled by another
Okay, agency? So I can brush that one aside. Then also,
the Attorney General has said from day one that there are over 280 cases under investigation. Surely he cannot do a briefing on 280 cases within an hour.
All right.
And so if you didn't hear about any case, you are most certainly going to hear about it as and when those cases mature for them to be taken to court.
All right, so then let me find out what about the PDS and also the National Cathedral.
280 cases.
Okay.
280 cases, Patrick. And therefore you've not heard about one case. Surely it will be broached as and when time goes on. When the Attorney General did his first briefing, he spoke about 2 or 3 cases. In fact, there have been briefings where he's spoken about just 1 case. So you cannot expect to hear about all the cases in one briefing. I think that those of you in the media must also help to avoid some of the narrative that tends to deviate from the normal practice. When a fact is obvious, you don't continue to belabor it. And I think we must help establish that. Thank you very much.
Thank you very much, Honorable.
All right.
So, good afternoon. My name is Emmanuel Romeo Tete. I work with Ahonto FM. Mr. Minister, there are growing concerns from civil society and political observers about perceived selective justice in prosecuting political opponents while shielding government allies. My question is, how does your office respond to such criticisms, and what steps are you taking to assure Ghanaians of impartial justice? Thank you.
Thank you very much. So last 2 questions, and then we'll call it a day.
Good afternoon. My name is Julius, and I report for the Ghanaian Times. Mr. Minister, mine has to do with the Edubuahin trial. His counsel has argued that there's no linkage between the property he has acquired and then what you claim is missing at his outfit. How do you respond to this? Do you still hold the view that Mr. Edubuahin acquired the properties when they even argue that those properties were acquired before he took office in 2017? And then, secondly, ORA was a major plank of the NDC's manifesto ahead of the election. 6 months down the line, 7, justice hurried, they say justice buried. Justice delayed is justice denied. What is how do you marry these two so that you don't disappoint Ghanaians who are urging to see the loot which people think has been taken out of the country recovered? Thank you.
Thank you very much. Yeah, so you have the final word as far as questions are concerned.
Honorable Machi, I don't know most. And I'll pay my question here, general question. Reset na President Mahama can was no. Yen na your toy because I had the papa. Me pese me bisa say. Me who a politician be akwada remand be more than 1 year na 6 months da. Ba kwa nsa wom sisi a obi timi da remand de san na sam kra ye mfre. Patro reset de bi be koso ana because Ghana wuni sika. Ase adwene bi abase wuni sika wasem sha. Ukoko to kura ntimi ndibem. Ata yi nipa ya yade ni tu mu a afa na yayi na pie se wonye eboni bia yi enipa egunsa wamu a omo sa situation womo drosso pa pacho eji sa situation wo be reset na okwan ben so e na afa so me pacho o menya sure se eya wudisem so obeti amonone na opeso obesom ne man yera honorable jachi question asem no megidi se president Mahama senki ebe yan sisanye bi ebe ma sa amra no emu adane kakra because me frija my north my bob bra kakra wa bruchi na pese me koso me manfo a enye criminal say baby am ya American ni kita passport na me sa wa Ghana passport enu ntimi nya ayi tumi e wo Ghana pacho sa amra no mo ye ne den e kodada na asesen pacho.
And attention, I'm not sure about your trip, but in the event that you didn't fully grasp it, okay, fine, that's okay. All right.
Honorable Minister for Government Communications, I do understand you, properly. It's just that I don't make an attempt to speak it. Because when I speak it, you know the Akan drama. You remember the Akan drama? Usually there will be a character called Musa or Atenga or something. The way they speak they speak the Chui, that's how I speak it. So I wouldn't want any I wouldn't make any attempt to speak it. So but I mean yeah, so the first question is in relation to review of section 35, right? You know, section 35 is a standard provision. In most common law jurisdictions, such regimes exist. Okay? So I mean it has rarely been used, and I don't know whether its use is necessarily inimical to public welfare. But if there's any assessment that the use of Section 35 is inimical to the public interest, it is left to Parliament to review it. It's not even a question of constitutional review because it's just a statute. Okay, so I do not think that in the current circumstances, I am, against the use of Section 35, and I'll definitely not be bringing any bill in Parliament to repeal it, because I don't think that it is necessarily in and of itself, okay, inimical to public welfare for people to be able to pay restitution and get non-custodial sentences. I do understand the need to exact full accountability and jail people, all right? But the existing legal regime must also be assessed in terms of its promotion of public welfare. If you look at Article 1 of the Constitution, it's very, very clear that all governmental powers must be exercised in the name of and for the welfare of the people of Ghana. So when we enact laws, we communicate to the public, the legislative position which we think is welfare, enhancing. If at some point in time we think that it is welfare reducing, we will, review and probably, repeal it. Now, there's this question about whether the agreement was made under the Plea Bargain Act. No, the agreement wasn't made under the Plea Bargain Act. All right? I took the decision because of the complexity of the matter. We merged the civil, okay, as well as the criminal aspects of it, okay, for purposes of a holistic negotiation that will result in an agreement. And so it is not possible to bring, for instance, the civil dimension under the Plea, Bargain Act. And therefore, I took the decision that let us look at it holistically, merge the two, and come to an agreement that will, enhance public welfare. Secondly, there was a question about vacation costs. Okay, yes, there will be some judges sitting during the vacation. Okay, and I expect that if the courts that these cases have been filed in, before, are sitting during the vacation, we definitely, myself, my deputy, and my team will definitely not have, a legal vacation. We'll have to stay to do the work. A question was asked about PDS, which, has been overruled by the Minister for Government Communications. So you see, you listed a whole number of them. All right. Once we get to a point where there is an update, I will give you, that update on it. So, for instance, if you take National Cathedral, okay, we just commissioned Deloitte to do a forensic audit. In addition to the normal audit that they did, they are going to do a forensic audit on it. Now, once I have the forensic audit, report, and the investigative report, is concluded, then I can announce that we have, concluded investigations in the National Cathedral case. Now, the question of selective prosecution, right? When I announced the the termination of cases involving former NDC officials and appointees, I gave reasons, okay, concrete reasons that legal professionals agreed with. All right, and I also said that the cases were not being terminated because of the political coloration of the persons who were before the courts. Okay, I assessed them on their merits, and then decided that I was not going to go forward with them. Right? I believe that the proof of the pardon is in the eating. So I have always said that when we come to a point where NDC current NDC appointees are being investigated and prosecuted, that is when Ghanaians will know that, I'm a man of my word. Okay? I have said it time and again that the fact that you are an appointee of this government doesn't mean that you are immune from prosecution. All right? But if you bring baseless charges against people, like they did to the finance minister, and then finally went back looking for evidence. You don't expect me, at my level, as a senior member of the bar, a former law lecturer, to come and look at that case and say, please proceed, because if I drop it, they will say because the two of us belong to the same political party. Okay, I don't take that as any serious criticism. All right. So yes, we are not engaged in selective prosecution. You will notice that there is a marked difference between what we are doing and what was done in the past. Okay, just look at the investigations. Look at what we did in, Kobina Edubohe. All right, and you will understand. Now, that dovetails into the question about Kobina Edubohe. The matter is sub judice, right? It is before a court of law. I wouldn't want to come out and rehash our case, in the media by, rebutting some of the arguments that the council have been making. But we have filed the case. We have evidence on record of the date of publication. The date of purchase of the properties with receipts from the real estate, people. We have the date of the construction of the Oyarefa, estate. So, and then the one at Asokoro Mampong. We have everything. So if council comes out to say that they were constructed or purchased prior to his being, appointed, then he should bring the countervailing evidence. All right. Edubohe was appointed in 2007 as a staff of the National, Signals Bureau. All right. It was in 2017 that he became the director of the bureau. Okay. So is he saying that from, before 2007, he bought those properties, or before 2017 that he bought those properties? Okay, so I'm not going to rehash our arguments, here to the media. Now, the question of delay. You see, if you go back to 2017, okay, by this time, how many people were convicted by the MPP? How many cases were filed by the MPP? In fact, trials hadn't started in any case, because remind you, okay, as a senior member of the NDC legal team, I was almost invariably involved in most of the cases that were brought. Or I used to, sometimes if I'm not counsel, I will attend court with, the Honorable Felix, Fosukwachi and co. All right. So by this time in 2017, had they convicted anybody? They are the ones who are leading this narrative that there is a delay in oral just to give us, a sense of desperation and, make us look bad. Okay. But come to think of it, I have given you an update where we have started trial. Look, when we file our charges. Within 2 weeks, we file our witness statements and supporting documents. That is a record. In the Atuforcing case, it took 6 months to file witness statements. You can go back and check. 6 months to file just witness statements. We file within 2 weeks. Okay, that should tell you how hard we are working and how diligent we are with our investigations. That is why I told Ghanaians that I will never go to court, okay, and file charges against anybody to persecute the person without evidence. I will never do that. And so there is no delay whatsoever. We are going at a very supersonic speed as far as oral is concerned. Now, also remember that, okay, conviction depends, on the judge, on the court. If I send the matter to court, I cannot be the one determining when the person is convicted. And so it will be, if I were laid back, allowing for long adjournments, not being serious with the cases and so on, then you can accuse me of delay. However, if I'm doing everything possible to ensure that there's speed and efficiency in the prosecution, okay, how can you blame me that there is delay in the execution of oral? Then also, my sister asked about remand. It is true, all right? And when you speak about this issue, to me, it is like carrying coal to Newcastle. The reason is because in my previous life, I ran the Center for Public Interest Law. That is separate. In fact, I established the Center for Public Interest Law years ago. And I did studies. You can go on the internet and Google studies on remand, the long periods of remand, in Ghana. And you are right. It's not usually the white-collar criminals who do that. It's the proverbial goat thief, the cassava thief, and so on and so forth. All right, they are the ones. Sometimes it's because they don't have money to hire lawyers, and the legal aid system is under-resourced, understaffed, and sometimes they don't even know that they are entitled to legal aid. Okay, so sometimes when we did our study, you get to Accra Central Police Station, and somebody has been in remand a police remand for 6 months. That is unacceptable. Okay, so the reset will include reset in the reform of the prison system. Okay, the UNODC, the United Nations Office on Drug and Crime, all right, is working with us, on what we call the Mandela rules. Okay, that will include shortening and the period in which people stay on remand. Now, on your question on dual citizenship, if I understood it, basically it was to the effect that the fact that somebody has gotten the citizenship of a foreign country should not bar them, from contesting contesting elections. That there is a bill which was pioneered by Professor Koku Asare, known on Facebook popularly as Koku Azar. All right, and we are working with him. He's taking it all the way to Mr. President. Mr. President supports it, fully, and I support it fully. I think that disability should be taken away, and so once in the constitutional review process, we are definitely going to touch on the question of dual citizenship and qualification to run for public office, because they are also our citizens. So I wish to thank you very much, ladies and gentlemen.
You have an update on the Ahmed Swale case?
Ahmed Swale, the report is still with CID. There's an update. There will be an update very soon because of the fact that some evidence is coming into the docket that was previously not made available. So I'll talk with Director CID and then give you an update subsequently. Thank you very much, and God bless all of you. Thank you.
Thank you very much, Honorable Attorney General, for those comprehensive answers. So this is where we draw the curtains down on today's program. We'll come your way on Wednesday with yet another Minister of State to delve into his or her sector and give us an update of where things are. So let me thank all of you for coming. See you on Wednesday.
So live here on TV3, this is News Central. Just the last, 28 plus minutes, we've been at the presidency where the Minister for Justice and Attorney General, Dr. Dominic Ayeni, has been providing details of ongoing cases in his office, most notable the Republic versus Dr. Kwabena Dufo and 7 others, which has become the subject of intense public debate after he filed a nolle prosequi. We have details of that plus reactions if you stay with us, including the National Peace Council condemning ongoing killings of students at Nalerugu Senior High School and Boku Technical Schools and assassinations in Asawase in the Ashanti region. Also, the National Teaching Council says it may request an extension from the Ministry of Education for the last batch of teachers who failed the recently conducted teacher licensure exam. We'll have the details if you stay with us shortly. A lot later, many children still struggling and often labeled lazy instead of getting support due to dyslexia. We have a special report for you. Let's get straight into our stories this afternoon, having to start off from the presidency, where we've been in the last 30 minutes because the Attorney General has been providing reasons as to why he filed a nolle prosequi in that case involving the Republic versus Dr. Kwabena Dufo. Remember, they've been in court over the UniBank bank closure, amongst many other things. In that address or release as issued by the Attorney General, he, amongst many other things, said they had recovered 60% of the assets, reason for which both the criminal and then the civil cases against Dr. Dufo and the 7 others had been discontinued. It's brought about a lot of public debate, many making the argument that, look, likening this to the analogy of a person stealing 10 goats and government asking the person to bring 6 and keep 4. The Attorney General said he had a huge announcement to make today, but he decided to allow that slide and deal comprehensively with all of the concerns that have come up from his release involving the nolle prosequi as filed in the Dr. Kwabena Dufo case. Let's take you onto the phone lines right now. Christian Malmhesi is a private legal practitioner who's as well been listening in on the Attorney General's address, and we'll seek to get an understanding from him. Mr. Malmhesi, I appreciate you joining us this afternoon on the bulletin. Your reactions to the further and better particulars as has been provided by the Attorney General this afternoon. He says that this agreement was not done under the Plea Bargaining Act because of the complexity of it. He also says that the 60% which was put in that release as have been recovered has not been recovered outright, but it's been put into sort of split into a number of years where payment will be made within 18 months, if I heard him correctly. A good deal still, you make the argument for the people of Ghana based on the explanations we've been getting.
Thank you so much for having me, and good afternoon to your viewers. I differ from the learned Attorney General. It is the reason that if you have a criminal proceeding ongoing at the criminal court, high court, if you look at the Plea Bargaining Act, it delineates copiously what the prosecutor, or in this case, Attorney General, ought to do in that particular situation. Attorney General maintains that it sidestepped the plea bargain because of the complexity of the case, because there were elements of both criminal and civil that were put together. And in any other case, the learned Attorney General had to engage the accused persons and see what they could recover. You see, it is so obvious that if if the agreement had been made under the plea bargain agreement, it would mean that under that particular act, it must be presented before the judge and it would be for the judge to accept or reject it.
Right.
Now, where the judge accepts it, the plea bargain agreement, they will be convicted on it. You understand?
Right.
And if the judge, in the situation where the judge finds it undesirable, the judge would reject it based upon the factors therein under the Act. Now, one would say, will it inure to the benefit of the accused persons, including Dr. Dufour, should they have been convicted on an accepted plea bargain? That enters into a realm of politics, which I will not conjecture because I'm not a politician. But the question is, where it becomes binding under the jurisdiction of the court, it serves the public interest than merely what has been done. So it is for Ghanaians, having explained the legal position, to judge for themselves.
So from what you're explaining to us, the decision to sidestep the plea bargaining act means that as a people, we're not going to benefit from this agreement because now there's nothing legally binding on Dr. Dufour and the 7 others to make even this 60% payment back to the state.
Yes, they could have an arrangement with Attorney General, but if they had come under the plea bargain, it would legally be binding all the same, and there would have been a conviction, because when the court accepts the plea bargain, there's a conviction on it. But as it is now, they have escaped that conviction, which would have happened under the plea bargain.
Well, the Attorney General, in making the argument about the complexity of this particular matter, cites an example he believes is similar in the Beige Capital agreement, which he also came to meet when he assumed office a lot earlier this year. He says that the reps of Beige Capital came to him with 10 million cedis and he flatly refused it. But now he can't even recover 50 pesos. And so if he compares the two, then really he stands better off in recovering some of the assets than allowing this to see the full haul of litigation. Also making the argument that this case has been litigated for a long time and it appears there's been no headway made. Hence, he's decided to make what he believes are possible savings to the state.
See, a concise and precise prosecution means that prosecution has every evidence on record to prosecute an individual or group of persons. If it is the case that the learned Attorney General had all his evidence sanctioned by him, and for which reason he held these people before the court, it matters not the nature of the complexity of the matter. Once there's criminal proceedings involved, the law requires that those persons be put before the court. Recovery is everything under the law. In our criminal books, there can be recovery, there can be fine, there can be imprisonment. In any case, the law provides for it. And this sounds more of a discretion which was not exercised judiciously.
So you still think, as a state, we're still on the losing side based on this agreement as reached by the AG and the accused persons?
I mean, definitely, if they begin defaulting on it, will it be for, because government is a continuum. Government is a continuum. So if the interest is to prosecute them, and under the laws they are to recover it, even as prosecution or conviction and sentencing, what prevents the learning Attorney General from putting them before? And like I said, the most important thing is that once the plea bargaining act has been sidelined, there is no way they would have been convicted, because if the plea bargaining agreement had been used, it would mean that where the court accepts it, Honorable Dr. Dufour would have been convicted based on the plea bargaining agreement.
Right.
And once that has been taken out, he has escaped that legal conviction.
And so this agreement cannot be taken to a court to enforce to enforce the agreement. One can make the argument that yes, it didn't go before the courts on a plea bargaining act, but it still can be enforced because it's an agreement nonetheless, and it can be taken into any court for a civil action to be taken against Dr. Dufour to repay this money.
I mean, yes, I mean, it is a contract, it is an undertaking that X amount of money I am going to pay over a period. So should I default? Probably I'm not privy to the agreement signed between AG and the accused person, but preferably other properties will stand in guarantorship or however AG would use to recover. But it will definitely mean that where there's a default, AG would have to go to court and enforce that particular agreement.
Right.
And so what would have happened if we had jettisoned on with the prosecution?
Right then, Mr. Mamhese, I'm sure the conversations will continue a lot more, but I appreciate you speaking to us. That's Christian Mamhese. He's a private legal practitioner speaking to us this afternoon on the latest from the Office of the Attorney General. The Attorney General himself, Dr. Dominic Ayene, who's been answering questions on a number of issues because he's had quite a lot on his plate since he assumed office. And here's a quick rundown or run through, if we can call it that, of the cases that some of which he's had to deal with since he assumed office, and those that are in court, those that are pending, those nolle prosequi has been filed. So these are the ones, if we want to make an argument based on oral, which is a big or a huge deal for Mahama too, in terms of his second term, President Mahama. On oral, there are two cases currently that the Attorney General is prosecuting in court. That's the first, Republic versus Professor Mayor Kumfi and Solomon Asama. That's the SkyTrain case. Then there's a Republic versus Edubuahi and two others that he's spoken quite a lot about during that press conference as well. Then there is the discontinuation of cases, which the most notable one, which he's been speaking a lot about this afternoon, having to do with the Republic versus Dr. Kwabena Dufour and some 7 others in the UniBank matter. There is the Republic versus Ms. Oponi, that's Cocoa Board. He discontinued that as well. The Republic versus Collins Dowda and others, that's the Saglemi housing project, that as well. And then Johnson Esiama, who is now the central bank governor. The big one is the NSS scandal. Other cases, that's yet to go to court. He provided some updates on this today, saying that there's been fresh evidence or details to which they've had to go into and possibly amend whatever charge sheet it is they are taking to court. Hence, they are not yet in court because he gave the assurance that in this month of July, they were going to take this matter to the court, but today's the 28th, and 3 more days to the end of the month. We haven't heard a word just as yet as to when this case is going to court. He says there's fresh update, details and evidence in relation to this. Hence, we're not in court. And so that's the latest in terms of what we know from the Attorney General and a host of other cases that he's been having to go through at this particular point in time. But we'll bring you a bit more stories right now and switching our attention completely from the Attorney General to peace talks in Boko, because the National Peace Council has condemned the recent killing of students in Boko and Nalerigu, as well as reported assassinations in Asawase in the Ashanti region. The council described the attacks as barbaric, cruel, and a gross violation of human rights, calling them a tragic setback to peace-building efforts. In a strongly worded statement, the council extended condolences to the bereaved families and urged security agencies to speed up investigations and ensure justice is served. He also expressed serious concern over the potential link between these incidents and the long-standing conflict in Boko, warning of growing insecurity in the region, especially in light of violent extremist threats from neighboring countries. Kwesi Irenchi is a senior public relations manager at the National Peace Council. Let's pick his thoughts quickly on the development. Mr. Irenchi, I appreciate you speaking to us. What's the council's expectation right now of security agencies? The government has issued a number of releases, says it is going into peace enforcement. What will be the expectation of the Peace Council?
Thanks very much for the opportunity, Marina. So like you've heard, we are just amplifying the bit of peace. We know that security have taken over. The IGP today, we understand, have gone to Asamase to meet with key stakeholders there. Of course, government directive to close down the schools in Boku and then Nalerego too had been enforced. So we largely commend them. And then our plea is for the parties involved to come to the peace table and ensure that we all work together to ensure the peace that we all need in this country.
There are legitimate concerns that these incidents might escalate the already volatile situation. In fact, the government in its statement says that this has set back the ongoing peace talks being led by the Asantehene Otufose II. What will be the expectation of that mediation committee now that we've seen this development play out? And what is the role of the Peace Council as well in all of that mediation conversation?
So ours is to facilitate efforts to prevent the conflict, of course, and then work with eminent members to ensure that the peace returns to Boku. So Asantehene's effort is one of the mechanisms we are actually working towards. In our statement, we mentioned it an ethnic committee meeting that was actually taking place in Boku before things escalated. So we're praying and then appealing to the parties to come back to the table for us to negotiate and continue the efforts to bring peace there. It's actually a long process. It's not a one-day event. So you just can talk. We ought to continue talking to each other and then appealing to the factions to give peace a chance.
Right. Kwesi, thank you very much for speaking to us. That's Kwesi Irenchi speaking to us. He's a senior public relations officer with the National Peace Council. Albert Yeliang is a national network coordinator of the Ghana office of the West African Network for Peace Building, WANEP. Mr. Yeliang, thank you as well for joining us. We've seen a lot of unscrupulous activities, a concern that some persons right now are seeking to take advantage of this insecurity to perpetuate their own agendas. How real of a concern is this? And now that we're seeing the government say they are going into peace enforcement, what should that look like?
Okay, thank you very much. It's unfortunate that over the past weeks, we've had incidences that again have raised our concerns as peace stakeholders. It is unfortunate that we've lost some lives, and again, lives that probably who in their persons do not have some kind of relationship to the Boko conflict. Indeed, some of them might have some relations, as we are gathering from the reports. But we'll appeal to the factions to remain calm. But the issue, as you raise, we have all along been thinking that the Boko conflict is not just about the factions, that there are possibly individuals and groups who are profiting heavily from the conflict, and which requires a lot more introspection, a lot more, investigation to understand the interlinkages that are occurring or that have been the ones facilitating the incidents in Boko. We know that over the years, as the conflict has prolonged, there have been arms within the civilian populations. Again, how many of the arms and ammunition is also with the other people who are directly engaging in violence, not just the factions who.
Hello, sir. Are you still with us? Well, it does appear we may have lost Albert Yeliang on the telephone lines, but it will take us on to our very first break here on News Central. When we return from this quick break, we talk the teacher licensure exam, because the National Teaching Council is seeking to put in a request to, amongst many other things, ask for an extension of some sort for persons who fail the recently written licensure exam. We have all of the details if you stay with us here on News Central.
Why are more and more professionals choosing Flamingo paint?
As an interior decorator, I aim for that beautiful, elegant look. Flamingo paint has great hiding ability to cover and transform old walls easily with just one coat.
Impressive. For me, as a professional painter, I love Flamingo paint because with just small paints, I paint huge area, meaning more profit for me. Great value for money.
As an architect, Flamingo Paint, with its well-researched and solid composition, guarantees durability for all my buildings.
Flamingo Paint, superior hiding, superior coverage.
Beyond the classroom. In its last manifesto, the NDC proposed cancelling the exams altogether, but instead, a committee was formed to consult the training colleges on the way forward. Board chairman of the National Teaching Council, Kwame Alovi, indicated that the committee suggested the exams should be included in the school curriculum.
We recommended, as captured in the NDC manifesto, that we would integrate the licensure examination into the final examinations of the colleges of education. When they are graduating, the licensure becomes part of their examination. So when they graduate, they will not wait in the house for another 1 year before going to write the license examination. And also added the practical aspect that was missing in the previous examination.
Teacher unions, however, say cancelling the exams is not the solution.
There were several scenarios. Some were saying that you write before you enter the training college or you enter into a training institution, but that is not feasible. You are not yet a professional. Why should you write an exam? The other one is that you write when you are exiting, after you have done all your exams. So these are things that, they will need to fine tune as to when the exam should be written and the kind of processes that ought to be followed, and it will be fine.
The ingredients that go into the licensure exam should be added to the colleges of education programs, so that by the time the person finishes school, he writes his exams, which has incorporated the syllabus of the licensure. And if he passes, he gets his professional certificate and his license. So that is his first stage of what? Licensure to teach. Then whilst he is in the service, he will be renewing his license with the National Teaching Council.
Just last week, Education Minister Harun Edrisu directed the National Teaching Council to allow the final batch of unlicensed teachers to sit for the exams this year. That group includes 60,000 candidates, who are now the last two to write under the current structure. But what happens to candidates who fail the exams, the last in its current form?
Some, about 30,000 plus, have written the examinations 2 or 3 times, multiple times, but are not successful. They are also waiting. And they cannot do the reform because they cannot go back to the colleges of education and write the new examination. There are some also who are just completed national service. They also need to write the licensure examination. They can't go back to college to write. Then there's a third category who have graduated from universities, colleges training teachers this year. So 3 categories. So we need to give them the chance to write the licensure examination so that they will not be denied of any employment. So the committee that I chaired recommended that we give them the chance to write the first one in July. We pray that nobody fail. But if somebody should fail, maybe it would be good for them to give them another chance.
And that's our bulletin for you this afternoon, which came to you from our studios here on the John Hammond Street. Unfortunately, we could not bring you that special feature on dyslexia because of time, but we spent a lot of our time this afternoon at the presidency, where the Attorney General has been providing details of. But you can catch that special feature on all of our social media handles, as well as on 3 News, our YouTube channel. Always log on to 3news.com for a lot more stories. I am Mawina Egbeta. Many thanks for watching. Up next, the afternoon show.